So I have been describing one of the examples of when law tries to import science into its legal doctrine. The book also looks at times when we try to export law's problems to science, in which we give too much power in the courtroom, essentially, to the scientific experts. The book also describes more subtle examples. For example, a Supreme Court case on environmental law, law and economics examples, from criminal law. The point in all of these is that we allow ourselves again and again to believe that law's problems will disappear if we turn to science. And that fails time and again through each of these examples that I go through, going back about 200 years. I don't mean to suggest that we should ignore what science has to offer. Science has been and can be enormously helpful to the legal system. The question is really how to manage that role effectively. Now, I want to give you a current example. It's a legal dilemma, and a variety of approaches have been suggested to resolve it. It provides, I think, a nice vehicle for looking at what might work and what is likely not to work. It's an antitrust example from the regulation of generic drugs. Now, in the United States, the generic drugs are regulated through what's called the Hatch-Waxman Act, that was in part, and it is intended to encourage drug companies to create generics and to challenge bad patents. The idea in very simplified form is the following. The first company that files for approval of a generic drug and challenges the underlying patent on the drug or the application of that patent to the generic version gets a 6-month exclusivity period. In other words, once that generic company gets to market, no other generics will be allowed to come onto the market and compete with it. It's a way of giving generic companies an incentive to do battle with the big guns and the many ways that patent holders can maneuver to keep generics off the market. But patent holders are quite creative. They are inventors after all, and they have begun entering into settlements with the generic challenger. And here's how the settlement goes. The patent holder pays the generic. Generic agrees to stay out of the market for, say, 5 years. The settlement is good for the generic. The generic gets paid and doesn't have to pursue a lawsuit. And these lawsuits are usually quite expensive. And when the generic does enter the market in 5 years, it still gets a full 6-month exclusivity period because the clock doesn't start ticking until the generic actually gets to market. If the patent is invalid or weak, the patent holder gets to hold on to its monopoly for 5 more years. And it does it by sharing some of the monopoly profits with the challenger. It's a neat deal, and one that economists tell us is potentially anti-competitive. So what do? On the one hand, there is tremendous potential for abuse in these types of settlements. On the other hand, settlements play an important role in the litigation process. They embody judgments about the risks and costs associated with any litigation, even when a case is quite strong. So it's a classic dilemma for the legal system. We understand the potential for abuse through the insights of the social science of economics. What I want to show you is the potential solutions that have been offered and how we can use this economic insight effectively and how we can't. So here's the question. Should a court allow patent holders and generics to settle a Hatch-Waxman claim when the settlement involves payment and delayed entry? Now, one prominent law and economics scholar has argued the following. Courts should allow such settlements when the settlement would generate at least as much consumer surplus as consumers would have enjoyed had the settlement not been reached and the dispute instead resolved through litigation. It is an elegant solution to a complex problem. It uses economics to give us a legal rule to live by. But living by that rule requires the type of complicated economic calculations that courts simply aren't very good at. It is bad enough to ask a court to measure consumer surplus and to measure it in 2 different circumstances. But the court, for that rule, must also measure it in the hypothetical world in which the litigation proceeds. It's not something that the court is going to be very good at doing, and certainly not with any degree of precision or accuracy. And if we're not measuring with any degree of accuracy, what are we doing with this type of rule? The fact that we can't measure with confidence, however, doesn't mean that we can't use the insights of economics to craft a solution. The book describes a variety of other potential solutions that would realign the incentives of the parties to make it either less likely that they would collude, or rules that would allow settlements only if the patent holder is likely to succeed on the merits. And likelihood of success on the merits is something that courts do all the time when they're looking at injunctions. The point is that we can do this not by crafting measurements or by deferring to economists to do the measuring for us, but in a way that allows courts to develop the kinds of solutions that courts are good at applying. I'm not trying to suggest that all measurement should be excised from legal rules, nor can I claim that all problems can be solved by aligning the incentives of the parties with society's incentives. My point is simply that the more we can stick to rules that reflect the kinds of things that courts are designed to accomplish, the better results we are likely to have. And the book describes some other aspects of finding a more effective intersection of law and science. The one that is nearest and dearest to my heart involves speaking in a common language. If scientific insights are going to play a supportive role in the legal process, they must be expressed in a language that legal actors can understand. And instead, in the patent area, we tend to write and speak in highly stylized, code-like jargon. And that jargon can obscure a failure to grasp the full meaning and implications of the legal issues. We very often just take language from the briefs and insert it into the decision without processing through the mental steps it would take to actually understand what is happening. Using this type of jargon creates the temptation to engage in a form of sophistry, to speak in what Nussbaum describes in the context of philosophy as a seductive, jargon-filled way that leads us to believe we have mastered something deep for having learned to use the jargon. So I suggest that whenever possible, we try to move towards plain language patents. And I believe we cannot effectively engage in the process of interpretation and adaptation unless we are speaking a common language that everyone can understand. Again, my goal in the book is not to keep science away from the courthouse door. Science has been, can be incredibly effective, but managing that relationship is important for finding effective legal decisions. And unless we begin to understand the roots of some of the problems we've had in the past when we try to import scientific structures into law or export law's problems to science, it's something that we are likely to continue again and again with no greater satisfaction than we have had the first time. Thank you very much for listening to the presentation.